Good afternoon, and thank you very much for coming back to this courtroom. Before I give the floor to legal representative, I have one clarification which I'd like to seek from Mr. Attorney General regarding the interpretation of Kenyan law, which I may repeating myself, and Mr. Attorney General has already responded. In that case, forgive me, but I need this specific clarification. When you talk about judicial request mean that you need a court order, I mean Kenyan court order in order to execute. The requesting body also should be always a court, in this case, this chamber. And is that so, for example, in case of bilateral mutual legal assistance treaty, in order for requesting government, for example, if it is the mutual legal assistance treaty between Kenya and UK, in order to make a judicial request through that treaty, UK government has to have a court order to that effect, or just the prosecution request is suffice?
Madam President, I'm happy to answer your question. First, I want to clarify that we have in Kenya, as in many other countries, an independent mutual legal assistance act. It applies to mutual legal assistance across the board. Its provisions do not override where there is a specific treaty obligation. For example, we have a whole corpus of law on extradition, and that we have, let's say we have two sets of laws on extradition, one covering Commonwealth countries as a special category of countries, and another one covering the rest of the world. That law is a law of general application. Where there is another methodology specific to another treaty, that specific overrides the general. It is not a requirement that every mutual legal assistance request should be contained in a judicial order, because as we have sought to demonstrate, there are very many mutual legal assistance requests of a non-judicial character. For example, we receive routinely from many countries around the world.
I'm sorry to interrupt, but I'm talking about judicial request. In case that any country with which you have this mutual legal assistance treaty, whenever this country requests assistance in getting document, and if this request comes under the heading or comes under the category of judicial request, the requesting country always need court order or not?
Well, it depends, and it goes back to the discussion in the morning. It depends on the nature of the request. If we were to be requested by any government to arrest and surrender a person, that would have to be contained in a judicial order that we are enforcing. A prosecutor in a foreign country cannot tell us, I am investigating the crime of murder in London, please arrest in Nairobi Mr. XYZ and send him over to me. We cannot do that, and that can't be done. But we can receive from the Crown Prosecution Service, from the Serious Fraud Office, from any other competent authority, a request, for example, to confirm, are the following companies registered in the Registry of the Republic of Kenya on Companies as foreign British companies. And we don't need a court order because that is a straightforward request that can be enforced outside a court order. So my answer, like it was in the morning, is we need to remind ourselves what is the character of the request. Some requests do not require any court order or any judicial intervention of any nature. Others must, by their very nature, be embodied in a judicial order. Otherwise, they would be in violation both of Kenyan law and I think of international law.
Thank you very much. Now I give the floor to legal representative of victims to address issues which we have been discussing.
Thank you, Madam President. The model for state cooperation, which is set out in the ICC's structure, insofar as it is relevant to today's proceedings, is set out in Part 9 of the statute, Chapter 11, Section 1 of the Rules of Procedure and Evidence, and Chapter 7, Section 1 of the Regulations of the Court. And in Kenya, that model is set out, as we know, in the International Crimes Act. The model attempts to reconcile three competing interests: state sovereignty, individual liberty, and the deterrence of atrocity. Now, the model was agreed to by the states parties after very extensive negotiations in which Kenya also participated. Kenya is very much a co-author of that detailed and delicately balanced model of state cooperation. I submit that there are four themes which run through that model, whether you look at the statute and the associated ICC instruments, or whether you look at the International Crimes Act. First, state parties must cooperate and must comply with requests for assistance from the ICC's prosecutor in its investigation and prosecution of crimes within the jurisdiction of the court. This is not an option. It is not a favor to the court, nor to the victims of the crimes charged. It is an obligation. Now, in a decision in the al-Bashir case concerning the failure of the Republic of Malawi to arrest Omar al-Bashir, paragraph 46, Pre-Trial Chamber 1 said, "Indeed, it is the view of the Chamber that when cooperating with this court, and therefore acting on its behalf, states parties are instruments for the enforcement of the jus puniendi of the international community," unquote. Now, that arose in the context, of course, of Malawi failing to arrest al-Bashir, President al-Bashir of Sudan. I'd like to note in this context that Kenya also failed to arrest Omar al-Bashir when he visited Kenya upon the inauguration of the Constitution in 2010. This concept of an obligation to cooperate appears in the statute in Articles 86 and 93, subsection 1, and appears in the International Crimes Act in sections 76, 77, and 104. The second theme is that states must comply with requests for assistance promptly. This concept of prompt compliance comes out particularly strongly in the International Crimes Act. The words which appear in that act are promptly, immediately, without delay, urgently. I refer to sections 26, 76, 84, 86, and 95 of the International Crimes Act. Some of those provisions relate to surrender of persons. Some of them relate to access to evidence. The third theme is that a state is expected to make a genuine effort to cooperate. If a state feels that it cannot meet the request for assistance, it must find, or at least explore, other ways to meet the request. That comes out in Article 93, subsection 3 and subsection 5 of the statute. It appears in sections 24, subsection 2, section 111, and section 112 of the International Crimes Act. And the fourth theme, which I submit appears is that if there is a legal barrier to cooperation, the state party must consult with the court promptly and without delay. That appears in Article 93, subsection 3 and 97 of the statute. It also appears in Regulation 108, subsection 2 of the regulations of the court. And in the International Crimes Act, it appears in sections 24, 111 and 112. Now, I wish to re-emphasize a point I've made, I think, a couple of times. The obligation is not on the prosecutor to prosecute the non-compliance by the state. The obligation rests squarely on the state party to consult with the court. The difficulty in this case is certainly not with the enabling legislation. In many ways, I respectfully submit the International Crimes Act 2008 is a model for enabling legislation. The problem is that the Attorney General has failed to comply with its provisions. Now, I wish to go straight to what happens when the Attorney General receives a request. Under Article 93, subsection 1I, i.e. the provision of records and documents, he must turn to section 104 of the Act, as I mentioned this morning. If the request appears to fall under Article 93, subsection 1L, then the Attorney General must turn to section 108 of the Act. Now, whichever section the Attorney General turns to, or to put it another way, whichever section the request relates to, the discretion given to the Attorney General under the Act is very limited. He must satisfy himself of two things. First, the request relates to an investigation being conducted by the prosecutor or any proceedings before the ICC. And second, the document or record sought is or may be in Kenya. That's the extent of the inquiry that he's expected to carry out, or indeed permitted to carry out, under sections 104 and 108 of the International Crimes Act. Now, one of the letters referred to by Mr. Gumpert, I believe, was dated the 6th of December 2012. And at page 2 of the prosecution's letter, the prosecution refers to an assertion made by the government of Kenya, in which the government said, quote, "The government is convinced that the court, through the prosecutor, has the evidence necessary that it needs to prosecute the trials," unquote. Now, that assessment clearly falls outside the ambit of the Attorney General's discretion under either Article 104 or 108. That assessment by the Attorney General is entirely irrelevant. Now, when the Attorney General satisfies himself of the two branches of the test that I just referred to, he shall forward the request to the appropriate Kenyan agency. He has no discretion about that. He must send it on. And when the agency receives it, without delay, it must use its best endeavours to comply with it. Now, there is no express follow-up duty set out in that part of the International Crimes Act. But I submit that the spirit of those sections, and indeed the entire Act, suggests that the Attorney General should be following up with the agencies that he sent the communication to say, well, how are you getting on? Have you found anything? When can I expect to receive it? And do you have any legal problems which I should raise with the court? And as far as I've seen, and I wish to emphasize, I'm not privy to all of the correspondence. In fact, I'm only privy to that which I was provided yesterday, as well as Mr. Kay. But I have not seen anything to suggest that the government's follow-up has been particularly impressive in the circumstances of the present proceedings. Now, in the Attorney General's submissions, both written and oral, there has been a suggestion, I understand, that incriminatory evidence relating to a Kenyan citizen cannot be disclosed to the ICC without the consent of that citizen. I won't repeat Mr. Gumpert's submissions, which he has alluded to, I believe. I fully support what the prosecution has already said in writing on this. But the argument is itself totally inconsistent with the International Crimes Act. Almost the entirety of sections 95 to 104 of that act deal with providing evidence to the ICC where that evidence is located in Kenya. It includes search and seizure operations. There's no reference anywhere in the International Crimes Act to any obligation to obtain the consent of the suspect. Nor is there any reference to any obligation to consider the privacy rights of the suspect. I accept that the right to privacy appears in the Constitution, but as I believe your honours have already alluded, the right to privacy in most jurisdictions exists, and the right of law enforcement authorities to gather the evidence that they need to uphold the rule of law and to hold accountable those for crimes also exists. The right to privacy never trumps the latter of those rights. Clearly, sections 95 to 104 of the Act envisage the provision of evidence which will incriminate a Kenyan citizen, as well as the provision of evidence which will exonerate a Kenyan citizen. The only legal barriers to providing assistance to the ICC, which are expressly identified in the International Crimes Act, as far as I could tell, are those in sections 109 and 110. I'm open to correction. I don't believe that the Attorney General has raised 109 or 110 as barriers in the present case. Let's turn now to the subject of consultation. As I've said earlier, the obligation of a state party to consult with the court if a legal difficulty emerges when the state party tries its best to comply with an RFA runs through the International Crimes Act itself. It comes up time and again. See, for example, sections 24 subsection 1, comes up again section 24 subsection 2, section 44, section 45, section 54, section 114, section 115, section 156, section 157. These provisions concern a wide range of areas, including the surrender of a person, providing access to evidence, and concerns relating to state security. But the message is absolutely clear. If there is any difficulty with complying with a request for assistance, the solution is to consult immediately with this court. Now, the request for assistance at the heart of these proceedings is dated the 24th of April 2012. The government of Kenya initiated the Article 93(3) consultation process on the 20th of December 2013. In my submission, that is simply not in accordance with its obligation to consult promptly and without delay. That delay in initiating consultation is itself a violation of both the Rome Statute and the International Crimes Act. In this morning's proceedings, there was some discussion about two issues. The first was whether the court order necessary to obtain access to evidence in Kenya must be an ICC court order or whether it can be a domestic court order. And the second point, which I believe has arisen both in written and in oral submissions, is whether it is the duty of the Attorney General to seek a court order or whether it is the duty of the prosecutor to seek a court order. And I'd like to identify a few submissions which might assist on this point. The International Crimes Act in sections 96, subsection 2, section 107, and in the second schedule to the Act at sections 3, 8, 17, and 23, subsection 1, contains repeated reference to situations where a court order is sought in Kenya with the authorization of the Attorney General. In some of those, in at least one, it's sought from a magistrate. In others, It's sought from the High Court of Kenya. In at least 3 of those provisions, as I recall, it is a police officer who will request the court order, having been authorized to do so by the Attorney General. So the clear model, which appears in the International Crimes Act itself, is that if a court order is necessary, it is a domestic court order, and it is essentially the duty of the Attorney General to make the arrangements for someone to go to court and to request that order. I haven't seen any reference anywhere in the International Crimes Act to an obligation on the prosecutor of the ICC to go to a domestic court in Kenya in order to request a court order. Nor do I see any reference in the International Crimes Act that the prosecutor provide an order from a trial chamber of this court in order to gain access to evidence in Kenya. I'd like to pause for a moment here to raise a question. What is it in the requested documents? And I'm not focusing just on the documents which are the subject of today's Article 87(7) application, but on all of the documents referred to in the prosecution's annex of the 31st of January of 2014. What is it in them that the government is so worried about? Why don't they want your honours to see them? Why don't they want the prosecutor to obtain them? If there's nothing wrong in there, why don't they disclose them? Now, I also would like to briefly point out that both the Attorney General and the President are obliged, under the Constitution, to uphold the constitutional rights of all Kenyans. That appears in Articles 131 and 148 of the Constitution. Why, I ask rhetorically, is the Attorney General so firm and unyielding in his defence of the rights of the 3 Kenyans on trial before this court, and, as far as we can tell, wholly uninterested in the rights of the tens of thousands of Kenyan citizens who are the victims of the crimes of this case, and who have an equal right to see the rule of law upheld in Kenya? And that rule of law includes the International Crimes Act and includes the Rome Statute, which, as the Attorney General pointed out, has been domesticated. I'd now like to turn to a couple of arguments made by the Attorney General in his filing dated the 20th of December 2013. It's filing number 877. I'll run through these points fairly quickly. The Attorney General has referred to the Public Officer Ethics Act and has criticised the prosecution in part because the prosecution has failed to identify the correct commission that it sought the records referred to at paragraph 10 of the request's letter. Now, a bit of background might be of assistance here. The Act, as I understand it, focuses on the conduct and performance of public officers and seeks to improve service delivery to the public. The Act defines a public officer. It includes employees of the government or any department, service or undertaking of the government, the National Assembly or the parliamentary service or a local authority. And it requires those individuals to provide an annual declaration of income, assets, liabilities, etc. Now, there are a small family of different commissions which are covered and identified under Section 3 of the Act. It should be very easy for members of the Attorney General's staff to identify which commission applies to Mr. Ruto, which commission applies to Mr. Kenyatta, and which one applies or applied to Mr. Muthaura. Mr. Sang was not a part of this, I understand. Yet the Attorney General has nevertheless thrown the duty to identify the commission back on the prosecution. And yet he's taken the position today, and indeed he took the position in a filing 1184 in the Ruto and Sang case of the 10th of February 2014, at paragraph 23. The Attorney General said, "It is thus not the prosecution's place to set out the national laws that apply and the procedures there are as they relate to the appearance of witnesses," unquote. His point was that the prosecution had improperly arrogated to itself the power to interpret Kenya's national law, and he's maintained that position here today, I believe. Now, the Attorney General cannot simultaneously argue that the prosecution has failed to identify the correct commission to which a request should have been sent, while saying that the prosecution basically has no standing whatsoever to interpret the law of Kenya. The government submissions of the 20th of December 2013 refer to a Civil Aviation Act which is no longer in force. Specifically, the government referred to Civil Aviation Act Chapter 394. That act was repealed by the Civil Aviation Act number 21 of 2013. Indeed, at section 83 of the 2013 Act, a side note expressly notes that Act 394 has been repealed. It is the 2013 Act was assented to on the 14th of January 2013 and entered force on the 25th of January 2013, with none of the confidentiality clauses of the earlier Act. The 2013 Act does contain one clause, which I'll read into the record to save us looking it up. Quote, "Aviation safety and security information obtained, gathered, voluntarily, or otherwise given to the authority under this Act, or regulations made thereunder, shall not be put to any inappropriate use," unquote. Now, it's clearly the appropriateness or otherwise that guides the authority in deciding whether to share information. And clearly, information relating to crimes committed against thousands of Kenyan citizens is certainly the kind of information which is put to appropriate use and should be disclosed under the new Act. I want to turn briefly to some aspects of the Constitution. There has been reference to the powers of the Attorney General under the Constitution. I would like to identify a couple more provisions which haven't yet been referred to in the Constitution. Your Honour, Judge Henderson noted that it is the President who appoints and dismisses the Attorney General. I'm slowing down for the benefit of the transcriber. That is section 132, subsection 2b. Under section 152, subsection 1c, the Attorney General is a member of the Cabinet. Under section 240, subsection 2f, the Attorney General is a member of the National Security Council. Elsewhere in the Constitution, we see that the President chairs Cabinet meetings. The President appoints all of the Cabinet secretaries, that is to say, he appoints the Minister for Finance, he appoints the Minister for Foreign Affairs, for Land, for Education, for Health, all of the ministries which we would find in most countries. It's clear, therefore, that the Attorney General sits right at the heart of government. It is also inconceivable that cooperation with the International Criminal Court by the government of Kenya was not discussed in cabinet meetings over the past year in particular, since Mr. Kenyatta took office as president. Under the International Crimes Act, it is principally the Attorney General who is responsible for coordinating the compliance of requests for assistance from this court. And we've referred earlier to the fact that under the Constitution, it is the President who is obliged to ensure that the Republic complies with its international obligations. And the President has the power to appoint and dismiss the Attorney General. Your Honours, consider for a moment, and I'm not referring to the current Attorney General, consider the hypothetical situation of an Attorney General who deliberately sets out to violate on a daily basis every international agreement to which Kenya is a party. The Vienna Convention relating to diplomats, for example, the Charter of the African Union, the Charter of the United Nations, the Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation, hostage-taking conventions, terrorism-related conventions. If we were to have what I might describe as a rogue prosecutor going into work day in, day out, violating the obligations of Kenya, is the President expected simply to sit there and watch? Is he expected simply to let this rogue Attorney General get on with this job of violating the country's obligations? Of course not. The President must then step in and dismiss the Attorney General. So it is absolutely the position, in my respectful submission, that the President, as the Constitution sets out, is the person ultimately responsible for ensuring that the Republic complies with its international obligations, and any failure by the Republic to do so is ultimately the responsibility of the President. Your Honours, I know you're already familiar, because His Honour Judge Henderson has already referred to the extensive nature.
Mr. Gaynor, I'm sorry to interrupt you. We have to finish this status conference today.
Yes.
Because tomorrow there will be another status conference
Right.
for another case.
I'll-
So I appreciate if you could just not speed up, but to limit your submission to
Certainly.
the most important parts.
Certainly,
only.
certainly.
Thanks.
Just two more points, and we'll be responding in writing to the government submissions of yesterday. But the President of Kenya is not a ceremonial office. It's nothing like the President of Germany or the President of Ireland. This is a President with very heavy executive powers. Those are set out, as you know, at length in sections 131, 132, and elsewhere in the Constitution. The final point, and I'd like quickly to update Your Honours on something that I referred to in the submissions in the last status conference. It's relevant to the question of non-prosecution. I told Your Honours that we were waiting for a report from the multi-agency task force. Now, the Director of Public Prosecutions confirmed on the very same day as that status conference that the multi-agency task force has finished its review of the 4,000 plus files, and that not one of them is prosecutable. That ironically was in Naivasha on the 5th of February 2014. For the record, I'll simply read what he said, and then I will finish my submissions. Thank you. The Director said, quote, "Of the 4,000 plus files that they have reviewed, none of them is prosecutable, none of them, and that is a fact, a sad and painful fact. None of them has been found to contain sufficient evidence to be prosecuted, whether as international crimes or otherwise. What I am saying, therefore, I am saying this, the sad and painful truth, we must face it, is that at present there are no cases arising out of the PEV that can be prosecuted before the ICD." I'll end that quote. And I would very much encourage Your Honours, when considering the prosecution's application, to focus not only on the specific request which the prosecution has chosen as a specimen charge of a litany of non-cooperation, but also to take into account the entirety of what has happened in this case, as I explained on the 5th of February in the status conference, as well as, for example, the filings by the victims dated the 6th of May 2013, filing 731, and also, very importantly, annex to the prosecution's submission of the 31st of January 2014. Thank you very much, Madam President.
Thank you very much. Now I would like to give the floor back to prosecution as I promised, and then I give the floor to Mr. Attorney General so that Mr. Attorney General can respond to the entirety of the submissions by other parties and participants. Prosecution.
Madam President, the procedure must, of course, be entirely a matter for you. Ultimately, this is an application by the prosecution. And in normal circumstances, in my submission, in these effectively civil proceedings, we're not prosecuting anybody here, we're asking for an order, which the court will make, I understand it, on the balance of probabilities, determining whether there has or has not been a failure of compliance. In those circumstances, those asking for the order would normally have the last word. I would invite you to consider whether, in fact, the sequence of proceedings which you have just outlined should be reversed. But if that doesn't find favour with you, I'm ready to make 4 separate points now.
Well, I think you asked the chamber for the time to go through all those exchanges, and I think it's better if you proceed with.
I take no further point. I raise the matter. If Your Honour's against me in the end, who speaks when probably doesn't matter very much. It's the quality of what is said, I'm sure, in the end, which will matter.
Well, I think we can come back to this issue later and see what will happen. Just a moment, please. Please proceed.
I'm grateful, and I'm sorry I need to seek a further clarification. There are 4 matters that I need to say to Your Honours, to submit to Your Honours at some stage. The first is just to clarify the letter which I referred to, but have now provided in written form. The second is the matter of who said what and when, which we referred to before lunch. The third is a brief response to the point which my learned friend Mr. Kay made, which centred on the word identify in the request. And the fourth is a matter which Your Honours yourselves raised about the possibility of the court now making an order effectively to supplement or double up on the prosecution's request. May I address all of those 4 now, or would you wish me to restrict myself simply to the chronology of who said what when?
Well, I think considering that we have 15 minutes, I think you should address 4 points at the same time. And how many minutes do you need?
I think I can manage in 10.
Okay, that's good.
Let me deal firstly with the chronology, because that joins up. I've dealt with the latter half of the chronology in responding. So let me start, and may I refer you to the binder which I provided, and take you immediately to tab number 3. RFA 45, the request for information, is served on the 24th of April. This response comes on the 14th of June, 6 weeks later, and it's a blanking response. We need more details. Another 6 weeks passes until we get to the item which is at tab 4. We're now on the 25th of July, or at least there is a meeting on that date. This is an email or a copy of part of an email on the 31st of July. And it appears from that there has been confusion in the mind of the Attorney General about whether it is this request or some other request from the registry. Do I understand I'm going too fast? No? Sorry. So it seems finally now, 3 months after the event, that things are clear in the Attorney's mind. The next item is the loose item. This was my error. I know I provided it this morning. I hope Your Honour still have it. It's a letter of the 7th of August. This was my error in not including it in the tabbed bundle, even if Your Honours can't find it, and I urge you not to spend ages because I've only got a few minutes left. It's the next instalment. On that date, some 2 weeks later, the Attorney General is for the first time addressing substantively the request the prosecution have made. What do they say? They do not say, we can't deal with this. There isn't a court order. On the contrary, request for financial information. We transmitted your request to the Ministry of Finance. So any reasonable reader would understand things are, albeit a little slowly, going ahead. The next item, which is at tab 5, the prosecutor writes back, and as he says, the slow pace of processing these requests is a source of frustration. Your Honours may think not surprising. 18th of September at tab 6, follow up for the above matters, and your letter dated the 11th of September. The relevant part is on the second page. Request for financial information for, amongst others, Githu Muigai, Kenyatta. We hereby attach the request sent to the relevant authorities. So again, what the Kenyan government is saying, yes, it's fine, it's just taking a little time, we've sent off the requests. Tab 7, 29th of October, more time passing. By now 6 months has gone by. And again, this is now from the prosecutor herself. Please hurry up. Time is running out. And the reference is made to the deadlines which have been imposed not by the prosecutor but by the trial chamber for the submission of evidence. The next item at tab 8. The Attorney General writes back on the 7th of November. It looks here as though he is for the first time making the submission he makes now. Request for financial information. There has to be a court order in place. If that sentence stood alone, then it would be very clear. But what he goes on to talk about is the request under Article 93K, not included in our submissions today. It's an order for freezing of property. And what he doesn't mention at any stage is the whole of the rest of the 17 headings of financial records. And the prosecutor takes him up on that at tab 9 and spells it out. We need to know what you're doing about the financial records. And that takes me to the point where I last began. So the chronological sequence makes it plain that at no stage, even as late as June of last year, and that is at tab number 18, I won't take you to it now, the Attorney General was recognising that the prosecutor had the right to make these requests. That's point number 1. Point number 2, Your Honours have the letter now in writing. It was a request to interview police officers. It was classically the kind of request which the attorney has called a request of a judicial character, which he has told you would have to be firstly coming from this chamber rather than from the prosecutor, and then being processed in the manner he's described. And yet we see clearly here that that is not the view the government of Kenya took in relation to interviews with those police officers, which I may say have never happened because there remains an injunction in Kenya, an interlocutory injunction now nearly 3 years old, which the government has never challenged. Those interviews, crucial interviews with police officers, have never taken place. Point 3, Mr. Kay's point. As a matter strictly of grammar and etymology, I immediately concede that using the word identify rather than copy and produce was probably suboptimal. It was not the best choice of the word. But is Mr. Kay really suggesting that we just wanted to know whether Mr. Kenyatta did have some bank accounts and that we wouldn't then be interested in knowing what the records were? That's not, respectfully, a sensible proposition. In ordinary circumstances, the process of seeking assistance would be an ongoing and collaborative one. Yes, the Kenyan government would say, he's got these bank accounts, these are the numbers, this is the current balance. Oh, we would say, that's very interesting. Please can we see the statements for this one, that one, and the other one? But we didn't even, to use the baseball expression, get past first base here. We didn't even have the documents identified to us. The idea that we are being in some way slightly disingenuous or misleading the court, it doesn't stand up. It is quite plain that what the prosecutor wanted was access to Mr. Kenyatta's phone records and various financial records, and we've never got them. And point 4 is a matter raised by Your Honours. Am I out of time? I hope I've got a couple of minutes left. Madam President, you supposed, you made no indication that this was the way the bench was thinking or the bench would ultimately resolve it, and indeed, I dare say you haven't decided yet, that one possible solution to the government of Kenya's first proposition, well, the prosecutor doesn't have the power to do this, it has to come from the chamber, would be for the chamber to make a parallel order so that that argument by the government of Kenya would then fall away. Madam President, that might be a rather pragmatic solution to disposing of that argument. And ultimately, it will be for Your Honours to decide whether to take that course. But it shouldn't be that way. There's an important matter of principle here which is much wider than just the proceedings in this case. It strikes at the root of the prosecutor's powers. The essence of what the prosecutor can do by way of investigations is set out in Article 93(1). That is plainly intended to cover the gamut of all of the inquiries which could reasonably be made of a state's party. Please help us in this way, that way, the other way, and then the catch-all at the end. If there's anything else, the state's party has to do that as well. It's vital that there is clarity. For the last 10 years, no state, including Kenya, has ever suggested that the prosecutor does not have the power to make those requests. Now, for the first time, that radical and novel suggestion is being made. If it is a correct suggestion, it will transform the way in which the prosecution carries out its duties under the Rome Statute. It will dramatically restrict the prosecutor's powers. Every time the prosecution wants to do anything which will require government assistance, we'd have to come to the court to do it. That's never been understood to be the way in which the prosecutor has to operate. And so it is vital, I respectfully submit, that whatever course the chamber takes with regard to ensuring that these items requested are eventually provided, and that's extremely important in itself, that the other important matter is also addressed, the matter of principle. There needs to be a declaration by the court that the prosecutor is indeed entitled to make such requests, that the prosecutor is indeed included within the word the court in the preamble to Article 93(1). And I respectfully submit that whatever ruling Your Honours make addresses that issue, and I, of course, invite you to find that the prosecutor does indeed have those powers. Thank you very much.
Thank you very much, prosecution. Now I invite representative of the Republic of Kenya if they want to make any
Yes,
response.
Madam President, I thank you for the occasion to respond very briefly to the observations that have been made. And I would like to start with the observation that was made regarding the responsibility of the President of the Republic of Kenya in regards to the enforcement of international treaties. I would have thought myself that it stands to reason that the reason the Constitution requires the President to appoint cabinet secretaries is so that they may carry out the functions, including the enforcement of treaties in their areas of specialization. If that had not been the case, the Constitution would have said that the President shall enforce the treaties himself. It would be an absurdity. The Constitution places one obligation on the President in this respect, and it is in section 100, article 132, 1(3), and it is to submit a report for debate to the National Assembly on the progress made in fulfilling the international obligations of the Republic. The fulfillment of international obligations by treaty on a day-to-day basis is entrusted to officers appointed for that purpose. The only obligation the President has is to report annually to the National Assembly, a supervising body. And I rest that argument and say no more. And then I would like to make reference to much heavy weather was made of an argument that the Attorney General is not an independent office and the occupant is not an independent officer. I think the research of Mr. Gaynor would have shown that there is a statute known as the Office of the Attorney General's Act, which states in the clearest possible language in section 16, subsection 5, that in the exercise of the powers and performance of the office, the Attorney General shall not be under the direction or control of any other person or authority. Maybe it for the completeness of the record, it should be shown that. Now, as to whether the individual Attorney General exercises independence, I do not wish to say anything that may appear like a personal defense of my person. But I do not know any person who would want to occupy that office merely to perpetuate his stay. I do not know of any ethical lawyer, and believe you me, Kenya has many ethical lawyers who would want to remain in that office by violating the Constitution and the law to which the person has sworn an oath to protect. And I say no more as to that. The distinction between judicial process and a non-judicial process is not only a commonsensical one under Article 93, it is also a legal one. It is inconceivable, in my judgment, that any court would countenance a situation where a person can be arrested and removed from the territory of a sovereign state on the instigation of a letter by a prosecutor. It would be inconceivable. If the rule of law means anything, it would mean that every decision of that nature would be subjected to judicial review. At any rate, if that is not the law in any other country, it is certainly the law in Kenya. Now, let me come to an issue raised relating to an opinion that has been placed before the court that has been attributed to my learned predecessor, the Honorable Amos Wako, and that is dated 4th October 2010. Two things are important here, Your Honors. Number one, on 4th October 2010, there was not a prosecution relating to Kenya. There was an investigation. the distinction between an investigation and a prosecution, I do not think requires any elaboration. That numerous prosecutions do not result in a prosecution, I do not need to elaborate upon. That the minute you have a defendant or an accused person or a suspect, the character of the investigation changes, again, does not need any elaboration. That in most jurisdictions, the difference between a statement under inquiry and a charge and caution statement under which the person must disclose that I am investigating the offense of murder and everything you tell me will and can be used against you, again requires no elaboration whatsoever. Number two, this letter is written during a transition period. The new constitution has come into force, but the director of public prosecution has not been appointed. Mr. Amos Wako is acting as the acting director of public prosecutions. Again, he is dealing simultaneously with a conflict that does not face us today, which I have demonstrated at great length. I think the less I say about that, the better, save to add this. Mr. Wako himself says, I am authorizing you to facilitate an interview. An interview. I don't know whether that is the language that the learned prosecutor suggests is to be found in Article 93. I have seen no reference to an interview in Article 93. Finally, it is a matter of record, the honorable judges, that the Kenya government, as soon as Mr. Wako wrote this letter, and as soon as the Chief Justice constituted a bench, the Kenya government ran into serious constitutional and legal questions arising out of the letter. And that is how the High Court, as a constitutional court, stopped this process by Mr. Wako and said this process was illegal and unconstitutional. I think that it is the obligation of the prosecutor to, at the very least, place those facts before this honorable court. I associate myself fully, honorable judges, with the observation of the learned Queen's Counsel, Mr. Kay. The prosecutor goes back over and over and over, glossing over the question of what is it they asked the Attorney General to do about the financial records of Mr. Kenyatta. The document speaks for itself, honorable judges. The document said, the OTP requests that the competent authorities of the Republic of Kenya should provide full financial profiles. I have not come across that language in the statute or the rules or anywhere else. Full financial profiles of so and so and so and so and so and so. Now, unless the prosecution wishes, which it can, because that is their prerogative and privilege, if they wish to serve a different request, that would be their privilege. They never served the request that they now claim before this court was never honored. There was never such a request. And I say no more about that. Mr. Gaynor is perfectly entitled to the very strong submission that he makes about the circumstances of the victims. And I want to place this on record, Madam President, because this is the position of the Kenya government and it has never changed over the last 6 years. The tragic events of 2007-2008 were very, very serious, admitted by all to have been so, and the Kenya government and the Kenya people committed themselves to ensuring that this would never happen again. And we had a peaceful election a year ago, the only evidence that you require of that. The Kenya government has spent billions of shillings on the resettlement of victims, on schemes to support the victims, not because the Kenya government is answerable to a third party about the treatment of its own injured victims of an unfortunate circumstance like this, because this is the very fundamental duty of every sovereign state to its citizens. We have done that. The material is on record. We continue to do that, and I can assure you we'll always continue to do that because that is our duty. We care about the victims. We are concerned about the victims. And anybody who has been to Kenya, and I challenge anybody who has been to Kenya and gone to contact the groups that have been working in this area, will confirm that a lot has been done. If more work remains to be done, we are committed to that work. But it would be a real absurdity to claim that the government of the Republic of Kenya has been insensitive or uncaring or unconcerned. It was said of my person as Attorney General that I have been firm and unyielding in favor of the accused, but unyielding in favor of the victims. I do not know whether I should respond to that. I do not know whether it was said in jest. I do not know whether it was intended as part of the serious material that the court should take into account. Let me say this, however. My job is to defend the rule of law. If in this court there is a proper defendant, properly presented to the court with the threshold evidence required by law, with request processed in accordance with the statute and the law, I shall comply. But I cannot possibly admit to an argument that says whether or not there is law in Kenya, whether or not there is a constitution in Kenya, whether or not you have an International Crimes Act, whether or not you have other laws, forget all that. We are telling you that because there were victims involved in this very unfortunate and tragic, do what we are telling you. The existence of a body of victims is enough justification for a disregard of international law, a disregard of constitutional law, and a disregard of other law. I refuse for my part to believe that that is to be considered a serious legal proposition. Mr. Gaynor also says that in his own judgment, it is inconceivable that the Cabinet of the Republic of Kenya could not, over the last year, have discussed the collaboration or cooperation of the ICC and of the Kenya government. I do not know his sources of information. I do not know whether he's privy to cabinet papers or cabinet minutes. But I have placed before you a signed statement in which I have controverted the possibility of that issue for reasons that are not far-fetched. The position in Kenya is unique. I don't think that needs any repetition. There has not been, and there is unlikely to be any reason for this case to be discussed as a cabinet matter, because the case and the process is being handled by independent office holders that cannot be directed by cabinet and that do not require the direction of cabinet. Finally, there was an argument relating to the DPP's view about what he should do or not do. Again, I dealt with this in the morning. The DPP is an independent office. But let me make this point, because again, when a half-truth is repeated many times, it wears the garments of truth. The cases that were reported in the critical phase of 2007-2008 were cases reported to police stations in a period of turmoil. Persons were on the move, communities were on the move for several weeks and sometimes months during the interment. And therefore, several police stations, and the DPP has explained this ad nauseum, several police stations received a single complaint: my house was set on fire. Immediately after the complaint, or soon thereafter, that family or that community would move to a place they considered themselves safe. When all these files were put together, including files of sexual assault and other files, they were actually not 4,000, they were 6,500 and something. And we shared that with the prosecution. The prosecution came to my office. I understand that the prosecutor in this court is presently probably new to the brief. The prosecutor's office came. We sat in my office. We went through the files with the task force. We availed all these files for inspection. That it can now be claimed that this candidness and this openness by the Kenya government was without factual basis, then the prosecution is in a position to say, when we reviewed your files, and unlike what you say, we found that 3,000 of them had evidence. They don't say that. They couldn't possibly say that because it would be untrue. As to what orders you can make or not make, I offer no opinion, because that is a matter that must lie between the applicant of this matter and the respondents to the matter. What I can tell you for sure is that if an application, a proper application for an order was to be made, we would ourselves require to be enjoined so that we could, at the earliest possible opportunity, guide the court on the nature of the processes that would be of assistance. And as I have said earlier before we broke for lunch, it is not a process that can be assumed would take a week or 2 weeks or a month or 6 months or a year. It would be an indefinite process because of the independence of the institutions that we have talked about. Finally, as my last comment to you, honorable judges, in thanking you for giving the Kenya government an opportunity to come and ventilate these issues, I want to suggest with tremendous respect that when you have looked at all the evidence on the record and considered all the submissions that we have made, you will find that there isn't in the history of this court any situation, country, that has ever done what Kenya has done. There is no situation, country whatsoever where this has ever happened. We take pride in that because it is our constitutional obligation. And maybe I can say this before I sit down. Two successful governments of the Republic of Kenya have been urged by the National Assembly in an overwhelming resolution, not once, but twice, to discontinue cooperation with the ICC. It is a matter of public record. What has the government done? The government has continued, despite those resolutions, concurring resolutions of two successful parliaments, we have continued to cooperate with the court. And that is why I'm here this afternoon. I do not think that that is what the prosecutor suggests is the experience that the court had in a number of countries that I shall not name because of the Committee of Nations. Officers of this court have been arrested and held incommunicado in several situation countries upon arrival at the airport. What has happened in Kenya? Each time the prosecutor has wanted to come, he has received state security, including paratroopers, to escort him throughout the country. Is that a country to be reprimanded? Is that a country to be rebuked? Or is that a country to be recognized as a model of how this court should work with situation countries? I leave it to your good judgment, but I thank you.
Thank you very much, Mr. Attorney General. The Chamber has a couple of questions to both Kenyan government and prosecution. First question is the question of requirement of consultation as referenced in Article 93.3 and 97 of the Roma Statute, which, as Mr. Gaynor pointed out, is mirrored in Article 24 of the Kenyan International Crimes Act. The prosecution also pointed out numerous exchanges between the prosecution and the Kenyan government. We would like both the prosecution and the government of Kenya to address whether or not they consider it correct to state that so far no consultations within the meaning of those provisions have taken place. And in that regard, we note that the government submission, which is 877 Annex 2, in paragraph 29, that they are taking this opportunity to initiate consultations. So in short, in your view, this consultation as provided in Article 93.3 and 97 has already started or not? Prosecution first, please.
Your Honours, the purpose of the consultation, as I understand it, is where the state, Kenya in this case, finds that there is a fundamental legal principle of general application, I quote from the statute, which is preventing it from complying with the request for assistance. Well, you've heard my submissions on whether there is or isn't, so I won't belabor that point. But I would say the applicability of this fails right from the start. This isn't some fundamental legal principle which is preventing cooperation, but just suppose that you find I'm wrong about that. The next thing is that there must be prompt consultation to try to resolve the matter. Well, even now that it's talking, as Your Honour points out, about consultation at the very last gasp, it isn't talking about consultation to resolve the problem, to get over this hurdle of domestic difficulty or the inability of the prosecutor to make such requests. It's saying flatly, you can't do this. You, the prosecutor, haven't got the power. That's not consultation, it is confrontation. So the answer to Your Honour's question is, I respectfully submit, consultation, whatever words may have been used, has not begun in any meaningful sense.
Thank you very much. Can Mr. Attorney General address this question? And I'd like to remind you that under those articles, it is for the requested state to initiate those consultations. Mr. Attorney General, please.
I want to repeat, Madam President, that as far as we are concerned, the clear requirements of Article 93 are that state parties shall, in accordance with the provisions of this part and under procedures of national law, we have been invited over and over and over again to ignore the reference to procedures of national law and to deliver ourselves to interpretation of what this particular part of the treaty means as interpreted by the prosecution. The prosecution says, a letter that says, we disagree with your reading of Article 93, and we disagree that it can yield the sort of outcome that you are suggesting. We have just been told a few minutes ago that that is not a consultation, that is a confrontation. So when do you, in the mind of the prosecution in this court, when is it that you are deemed to be consulting? It is when you accept every demand that is made of you without demur. Can there be such a reading of this statute? Then what would be the necessity of national law procedures? What would be the necessity of domesticating the Rome Statute? If the prosecutor is right, then what the prosecutor is saying, forget any other law or procedure whatsoever. The Rome Statute, as interpreted by the prosecutor, because the prosecutor is part of the court, is binding on you as transmitted in the request document. If you question anything in the request document, you have started a process of non-cooperation. I want to respectfully suggest to you, honorable judges, that an interpretation of that nature would create an absurdity. It would mean, therefore, that notwithstanding one of the most venerated traditions of international law, recognizing the distinction between the monist and dualist traditions, would have, by the single stroke of the pen of the ICC prosecutor, been resolved forever in favor of a reading of international law that says, if you sign a treaty...
Mr. Attorney General,
Yeah.
I'm sorry to interrupt. My question was quite simple. In your view, has consultation provided in Article 93.3 and 97 of Roma Statute has been initiated or not? And I presume from your previous written filing that your government view is that this consultation has not been initiated.
A formal consultative process has never been commenced at the instigation of either party. However, the nature of the exchanges between the parties, very elaborate, set out by the prosecutor, shows that the parties had an open and candid discussion. And we ourselves take the view that the prosecutor was entitled to take the position of law that he took, only it was a mistaken and misguided interpretation of the treaty and of Kenyan law. But that he was entitled to do that, we cannot question that at all. that he can question that we were entitled to interpret our own law is surprising to us.
Thank you very much. The second question for prosecution. Although you said you are not aware, you have not been aware of the detailed legal arguments of the Kenyan government up until very late stage, but still, couldn't you have seized the chamber before this timing, at a little bit earlier stage?
Well, if I were to say anything other than yes, I would plainly be lying. We could have. And looking back now, with hindsight, perhaps it would have been better if we had. But Your Honours will see from the correspondence that the Kenyan government was at no stage expressing the position that there was a complete bar because the prosecutor wasn't entitled to make this request. Indeed, in a rather tantalizing fashion, when its feet were held to the fire, when it was actually required to address the financial and telephone records which we're talking of, its frequent response was, if I can use the colloquial, the check's in the post. We're working on it. Even as late as June, as we see from their filing, there was an acknowledgement that the prosecutor was entitled to make such requests. There was a complaint about the fact that the prosecutor was publicly saying they're not doing what they ought to. But they weren't saying, no, you don't have the entitlement. Your Honour will recall that the trial was slated to start in July, and it was perhaps not unreasonable that the prosecutor was concentrating on the evidence it did have, rather than the evidence it had failed to obtain through non-cooperation. And indeed, when the trial date was adjourned until November. Similarly, the prosecution, for better or worse, with hindsight, was preparing for a trial on the basis of the evidence it had. It was when that trial date was adjourned, and I won't give Your Honours the details of the internal consultation, that it was decided that this motion, which had been long considered, now had to be pursued. So the short answer to Your Honour's question is yes, of course it could have been, and perhaps in hindsight it would better have been. But it can't be right for a matter like this to be determined on the basis of the prosecution having, with hindsight, acted a few months later than it might have done, when the real problem here is not those few months, but the 22 months which have elapsed since the prosecution uttered this perfectly valid request, and during which time the government of Kenya has signally failed to respond.
Thank you very much. And I'm glad to report to you.
Respond to that very briefly, please.
I'll give the floor after I speak. And I am glad to report to you that interpreters and court reporters and courtroom staff very kindly give us 30 more minutes, so we can sit here up until 4:30. Although I believe that we don't need 30 minutes more. Prosecutor, I think you finished.
Yes, I have. I was just going to thank the court staff for making that time available, although, like you, I sincerely hope that we're not going to eat up all of those 34 minutes.
Thank you. Mr. Attorney General.
I wanted to draw the attention of the court to, again, part of the difficulty that we experience as the government of Kenya, because the complaint now before this court, as we understand it, is that the case now pending before this court cannot proceed because there is evidence in the possession of the Kenya government that has not been surrendered to the prosecution by the Kenya government over the last 1 year or so. Reference was made to a communication in which I had previously expressed surprise by this contention, and I need to explain myself in that regard. Honorable judges will remember that when Kenya became a situation country and inquiry was opened, the former prosecutor of this court, and I have made extensive references to media coverage of his comments in public, he said over and over again, we have overwhelming, irrefutable evidence to prove, and he made his claim. When the confirmation hearings were held in this court, again, the prosecutor over and over and over again, as a matter of public record, said, we have overwhelming evidence in these cases that will prove these cases beyond reasonable doubt. This court, in its wisdom, and despite the dissent of one member of the court, decided that it had seen the evidence of the level that it required to see. That is the prerogative of the court. That is the discretion of the court. When the trial dates were taken, my recollection, again there was, if I remember correctly, an application by the defense suggesting that more time would be useful. And if my recollection is correct, the prosecutor came in person to this court and said, I am ready and all my evidence is available.
Mr. Attorney General, I'm sorry to interrupt, but let's limit our argument to the issue before us, which is
Okay, let me
non-cooperation
now come
issue,
to the issue.
and not going into the details of the case itself.
Okay,
which
let
is
me come
irrelevant.
to why I was telling part of the background. I wanted to demonstrate to you, Your Honors, that the prosecution has been changing its narrative continuously throughout this case. And the Kenya government merely became a bogeyman in this case very, very recently. That was never the narrative. There was never a narrative that this case has any difficulty occasioned by the Kenya government that would stop the case from going to trial. And therefore, as you consider this question of whether there ought or there can be or there has been any consultation, you must appreciate that the background is such that the facts demonstrate that the prosecution has never been interested in any consultation beyond asserting its right, consistently saying, we have already told you the law as we know it, now comply with it. I would therefore like to end by saying that in the view of the Kenya government, we have provided all the material that did not require under Kenya's domestic law for any special procedures to be invoked. And we have declined, and my own submissions, Madam President, will show this. We received over 40 requests. We received over 40 requests from the OTP. We complied with over 36 of them, if not more. Therefore, an argument that says that after considering 40 requests, you are obstructionist, you are uncooperative, you are stalling the case because you have raised a question about 2 issues or 3 issues cannot be, it cannot be supported by the truth. So we urge you then to consider everything we have placed before you and to find that we, like you did before when we came to you to be joined amicus, you made a finding that said the Kenya government should not in the future be the subject of adverse commentary in proceedings not availed to it so that it can respond to those adverse comments. We urge you to make the same finding now, that we have demonstrated that we cooperated, we gave everything that was not contentious, and where there was contestation, we gave good legal explanations, and that only this tribunal or a judicial tribunal can override our interpretation of the law. Thank you.
Thank you very much. And please be assured that this chamber will make any findings and any decision after carefully considering all the submissions from all the parties and participants. Judge Freeman has a question.
I have one additional question to defense. Mr. Kay, today we have listened extensively submissions of both government of Kenya represented by Mr. Muigai and from prosecution as well. But I still miss one thing, that is, position of your client. But if I'm saying position of your client, I don't mean position Mr. Kenyatta as a president, because position of government of Kenya, I think, was extensively reported by Attorney General. But I mean position of Mr. Kenyatta as accused. Do you think that you are able or allowed to indicate his position, at least roughly?
Yes, Your Honour. Any request for President Kenyatta in relation to his defence in these proceedings come to me, not to him. I'm his legal advisor, and I may or may not decide to exercise my defence rights, which this court must respect and has an obligation to respect. And so decisions concerning the trial are decisions that I make in a broader tactical understanding of what this case is about. We have never had any doubt about the falsity of the allegations. You saw our filing, the number of times we pointed this out in correspondence, verbally before the courts, and we specifically pointed to the issues that have led to the collapse of this case against Mr. Kenyatta. Witness 4, witness 11, witness 12. We were met, may I say, with unremitted arrogance in respect of our observations. We were delivering up tapes, interviews. We pointed out to the court that the man, witness 12, was a congenital liar, that witness 4 was a congenital liar. We were able to piece together the fabric that demonstrated those lies. No one listened to us. It's only when we come to the collapse of the case on the eve of trial that these issues were being raised as against us. I pointed out in the correspondence between the government of Kenya and the prosecution this morning what I thought was a salient fact going to the issues in the case in respect of proceedings on behalf of the prosecutor that were alleged on many occasions to have been trial ready. And in fact, the evidence that they had been seeking was nothing to do with the issue that they had brought before this court on the occasion of the hearing at our status conference. In relation to Mr. Kenyatta's position, may I point out to the court that there was another president before him, and this argument and exchange between the government of Kenya and the prosecution commenced long before he was elected president. And in fact, it barely rumbled after he was elected president. It only became an issue upon the collapse of the case. And may I point out as well that there are two sets of proceedings, two separate sides that are within the framework of this correspondence. It doesn't only concern Mr. Kenyatta. It concerns the accused in the trial of Kenya 1. All those arguments were happening before he became president. And so in the circumstances, at this stage, laying or trying to impute or say we are responsible for it, without a shred of evidence in support, is unfair and not right. And it's trying to deprive him of his just right at this stage, which is the termination of the proceedings because the case has been found to have been false. That's a very important matter at this stage, and why I was very concerned about us being dragged into this dispute on legal issues that we have never been a part of. In fact, last week, I thought the request for the financial records did concern the post-election violence and withdrawals of cash. And then when I see the correspondence and realize it wasn't, it did reinforce my submission of last week that this was a very convenient argument for the prosecutor to seize upon as an excuse and pass blame for their failure to find credible witnesses, honest witnesses, and ignoring repeated warnings from the defense. We have given much disclosure in this case. We invited the prosecution, without any knowledge about mention of cell site in these letters, to join as co-plaintiffs in proceedings in the High Court under Kenyan legal procedures, because we considered how this should be done in relation to the proceedings. In fact, the prosecutor did not want to join us as co-plaintiff. They issued a letter in support of the justice of our application. So in many respects, they are the architects of their own problems here, and seizing upon areas of evidence that they say now are important to the issue, in fact, I would submit, show that in their own minds, they were not committed to the evidence in this case. They were committed to the recycled narrative of the interviews of their spread of witnesses, an extraordinary set of interviews that we have analysed at great length. They weren't looking for extraneous, independent evidence that could lead them to the truth. We repeatedly put that before them. They weren't concerned about that. They were happy to peddle these Mungiki witnesses into this court to tell lie after lie after lie. And in our submission, we have come to the stage of these proceedings where Mr. Kenyatta is being brought into a dispute that had already been happening between the parties. I, as his lawyer, will exercise his defence rights as I consider them necessary and right to do so. And those decisions as to whether anyone had asked him, they wouldn't ask him. They would ask me, because he has given me the power of attorney to represent him. And no request was ever made of us. Those are my submissions. Thank you.
Thank you, Mr. Kay.
Thank you very much. Any parties? Mr. Gaynor.
Madam President, very briefly, I'd like to make two submissions in response to what the Attorney General said.
Very briefly.
Yes,
please.
very briefly. He referred to the billions of shillings that have been given to victims in Kenya. Well, I've personally met 575 of them in 30 meetings. The vast majority have received virtually nothing from the government. A small number received 10,000 shillings from the government once, and a couple of others received 1 tin weighing 2 kilograms of maize meal. That's all they received for 6 years in order to feed their families. So his representations regarding the overall character of assistance given to victims of post-election violence, especially in the Western and Nyanza regions, falls far short of the complete story. Secondly, I'd like to address his suggestion, which I believe is around page 95 of the transcript, that the Cabinet never discussed ICC-related matters. Now, the government of Kenya took very strong positions at the United Nations Security Council, at the African Union in Addis Ababa, and at the Assembly of States Parties in The Hague on a number of issues. At the Assembly of States Parties, the Kenya delegation included the Attorney General, the Director of Public Prosecutions, the Minister for Foreign Affairs, and, for example, the head of the Witness Protection Agency. And they took positions on Rule 68, which is designed to deal with witness intimidation and witness bribery. They opposed it completely. They managed to get some language put in the preamble of the resolution adopting Rule 68. They completely supported immunity for a sitting head of state from prosecution. They did that also at the African Union. And also, if immunity was not to be granted, they took the position that the head of state should not be present.
Mr. Gaynor, I think it's not a suitable place to discuss the immunity issue.
If I can finalize in one sentence, if all those positions were taken without consultation with the President of Kenya, I would be extremely surprised. Thank you very much, Madam.
Thank you very much. If there are no other submissions, that brings us to the end of the matters to be discussed today. We thank very much parties and participants, and our special thanks goes to the Mr. Attorney General and his team for their contributions, and also for traveling to this city of The Hague. And I would also like to thank the interpreters, court reporters, especially for additional time given to us, and other courtroom staff for their assistance. This status conference is now closed, and the court will rise.
All rise. We will there.